All right, Kim and Yuri, are you both about ready?
I'm ready.
All right, we will go ahead and get started. Thank you all for being here. This is exploring the environmental justices caused by gerrymandering, as well as some other more general discussion around democracy issues. Really excited that we were able to make it out here to Oregon. We're from Ohio. We also have a speaker from New York, and then also Kim, I believe you're in North Carolina, correct? Yes. So I'll briefly introduce our four speakers, and then I'll kick it to Yuri, who's in New York, for the first part of the presentation. So I'm Chris Tavener. I'm the Associate General Counsel and Managing Director of Democracy Policy for the Ohio Environmental Council. I'm based in Columbus, Ohio. This is actually my third time coming to the Oregon Public Interest Environmental Law Conference. Love making it out here to just learn from everyone who's at this conference. And so that's a little bit about me. I'll let my co-presenter here with me introduce.
Yeah, my name is Kalia Tejas, and I'm from Columbus, Ohio. I'm not an attorney. I'm here with Chris presenting on some work that we did together when I was the policy fellow at the Ohio Environmental Council. I have a BS in environmental policy and decision-making from Ohio State University. And this is my first time here, so I'm really excited. And I'll pass it on to our virtual presenters.
All right, Yuri, you want to introduce first?
Sure. Thank you. Hopefully, is that working? Is my disembodied head up on the screen now? Oh, wonderful. Okay, so hello, everyone. I cannot see the audience, but I'm guessing it's standing room only, just packed to the gills on this Sunday morning in Oregon. My name is Yuri Radinski. I'm a senior counsel in the democracy program at the Brennan Center for Justice here in New York. I am originally from the Pacific Northwest. I'm from Seattle, so I would have loved to have made it in person, get back to my Northwestern roots, but we had litigation deadlines, unfortunately. Before I jump in, I just wanted to thank the conference organizers. I wanted to thank my co-panelists for having me on, and of course for everyone in the audience, both here in Eugene physically and virtually as well. My presentation is going to be a 30,000-foot flyby of redistricting policy and litigation landscapes. Map drawing itself is now finished, or at least the first round of map drawing is finished in all the states, but litigation is ongoing, and the push for reform at the federal and state levels ahead of the 2030 census and the next round of redistricting is also underway. So redistricting, of course, advocacy is cyclical. We are in the cycle, and the work really doesn't ever end, which is good for me from a job security standpoint. And one of the reasons why I'm really pleased to be here and to have been invited to give this presentation is because redistricting advocacy is most effective when it's cross-disciplinary. On its own, the drawing of districts is fairly abstract. It's hard to get people to care other than a small subset of people that are either political superfans that follow politics really closely and really dive deep into things, people who are experts, or people who are democracy nerds. And the challenge with redistricting always is to connect it, to take that next step and to connect the way that districts are being configured, the way the process is playing out with real world consequences, things that people care about, be they kitchen table issues or things that they actually deal with on a day-to-day basis. And so today's panel will dive into how redistricting, or gerrymandering, which is the abuse of the redistricting process, intersects with environmental justice and so forth. And so I'll be just giving a broad overview to give everyone a common understanding of what the policy landscape looks like, what the legal landscape looks like, before my co-panelists really dig deeper and draw the connections between environmental advocacy and what they do on a day in, day out basis, and redistricting, which is what I do on a day in, day out basis. So before I get into the ins and outs, I think it's useful to just remind folks what redistricting is. And my definition is that it's the process of creating geographic political communities. And in the US, it's such a high stakes process because we break representation down geographically, both at a federal level, at a state level, and at a sub-state level. And these electoral districts at all levels of government are periodically redrawn. That's key to the census. And the idea, at least the highest ideal of it, is that there is a direct correlation between how the population in the US is evolving and the districts out of which our various legislators are elected should also evolve to reflect that population, both in terms of numerical changes, but also in terms of various other relevant demographic and social and economic changes that take place over the course of the decade. So in other words, the redistricting process at its highest form is about making sure that our legislative districts are actually capturing the population and are an accurate reflection of the population. And when it's done right, the idea is that it creates natural constituencies where people who share common political needs, common political interests outside of pure partisan affiliation can come together, form campaigns, and really can promote a grassroots type of politics where candidates are really vying on issues that are relevant to a particular constituency. In other words, there should be a glue that's separate and apart from just horse race Democrats versus Republican politics that makes a district work. Of course, given how much political power hangs in the balance, this process is often abused to either perpetuate the legacy of racial discrimination and draw districts in ways to disadvantage communities of color, to deny various racial constituencies an opportunity to fully participate in the political process, or by entrenching certain political and partisan interests. Oftentimes, these two forms of abuses go hand in hand. And so in order to avoid those sorts of outcomes and to produce fair representational outcomes, there are really three components to it. One, for fair redistricting, you need good data. And I won't be touching on that today, but good data comes from a complete and accurate census. Second, you need a fair process. And third, you need safeguards that ensure fair substantive outcomes. And so those two things, process and substantive outcomes, are really the things that I'll be touching on briefly today. So to begin, in terms of the policy landscape, we have 50 states, and we have actually more than 50 ways of drawing maps. Each state is distinct, and in fact, within each state, there can be two different processes, one for drawing state legislative districts and one for drawing congressional maps. The gold standard of good government policy and the gold standard of redistricting process is to use independent commissions. Of course, the issue is all reform will call itself independent. regardless of the reality of the structure of the particular commission or system that's being used to draw maps. We have a specific definition at the Brennan Center for what distinguishes an independent commission from other forms of commissions. So for us, an independent commission is one where commission members are screened for conflicts of interest. That means they are not sitting elected officials. It means they're not party officials. It means they don't have significant personal interest, vested interest in the way that the redistricting process plays out. It's a, for lack of a better analogy, it's a jury type system. You try to select people who, of course, have their political views, they have their various political affiliations, but they don't personally stand to gain from the way that the redistricting process plays out. The hope for independent redistricting commissions is that there would be balance and a balance of various partisan affiliations and views that are reflected. And the other defining feature is that independent commissions have to have the authority to pass binding maps. They have to be able to actually enact maps into existence. Now, these 4 states that you see, and there are some distinctions between California and Michigan versus Colorado and Arizona. We draw this distinction, and it might not be entirely fair, and at some point you're kind of splitting hairs, but basically in Arizona and Colorado, there is more involvement in the selection of commissioners or in the map drawing process from more political actors. And so we shade them slightly differently than we do California and Michigan, which are designed really to insulate the map drawers from political influence and that sort of thing. The next type of commission, and there are 10 states that use these, are political appointee and politician commissions. These are commissions that are often bipartisan. There are both Democrats and Republicans, and sometimes even tie-breaking members on them. But the idea is these commissioners are either politicians themselves, or they are directly selected by politicians without very many safeguards against who they can choose. And so there are far fewer checks on partisanship. There are far fewer checks on conflicts of interest. But of course, not all of these are designed equally well. Some of these work reasonably well. Others are very, very political, like the commission in Ohio, which both I and Kalia and Chris are intimately familiar with. But this is kind of an in-between reform option. Design really matters. The devil is really in the details. But these are the 10 states. So Alaska, Hawaii, Washington, Idaho, Montana, Missouri, Arkansas, Pennsylvania, and New Jersey use these, some for just legislative maps, some for both legislative and congressional. The last kind of commission is an advisory commission, and there's a lot of variability in what these look like. The common feature of all of these is an advisory commission cannot actually pass maps. Whatever they produce ends up going to the legislature, and there's still legislative process and lawmakers that end up making the final selection. Again, there are shades and degrees. There are advisory commissions like the one in New York, where the legislature can completely disregard the commission's work. And then there are commissions like in Virginia, where it's not, I wouldn't say it's the gold standard in terms of designing redistricting reform, but lawmakers cannot disregard what the advisory commission does. They can vote down the advisory commission's work, but then the process goes back to the advisory commission. They don't get to take over redistricting like they do in New York State. So all the rest of the states, the ones that haven't been covered by any of these commission slides, draw maps through their regular legislative process. That is the majority of states. And in many respects, these are the states where you have the highest propensity for abuse, places like Texas, places like Georgia, places like North Carolina, where that are very closely politically divided, where you have growing populations of communities of color, and that confluence of changing demographics, changing politics, and swing state or near swing state status is where you see the worst kinds of abuses. The way we get these abuses can be avoided and to produce good substantive outcomes, of course, is to have safeguards on the back end. From a federal law standpoint, there aren't that many tools that we have at our disposal as advocates. You have 3 different types of claims under the federal Constitution, under the 14th Amendment, to make sure that districts have equal population, that districts weren't drawn that intentionally target racial minorities, and also that race cannot be the predominant factor when districts are being drawn. You also have one statutory safeguard, and really the most potent tool that exists for safeguarding redistricting, which is Section 2 of the Voting Rights Act. Of course, the federal legal landscape is changing, and in many ways changing for the worse. In recent years, the US Supreme Court has slammed the door shut on bringing partisan gerrymandering claims under the federal Constitution in a case called Rucho v. Common Cause. It has gutted Section 5 of the Voting Rights Act, which required certain states with a history of discrimination to seek pre-clearance from the DOJ or a federal court before maps went into effect. And of course, there's a case out of Alabama that was brought under Section 2 of the Voting Rights Act that the Supreme Court is deciding right now. And the expectation is this last potent tool, Section 2 of the Voting Rights Act, will get harder and harder to use, which matters a lot because there are 13 states where there are Section 2 claims that were made this cycle, including Georgia, Louisiana, Alabama, and Texas, where we're involved in a lawsuit, and a number of others. The other legal safeguards, of course, come from state law and state constitutions. Their advocates have successfully used state courts relying on general constitutional provisions, or what I'll call general constitutional provisions. So these are things like state equal protection, state fair and free elections clauses, freedom of association claims, and certain others. And then there are some specific provisions that relate to partisan gerrymandering or to prevent racial discrimination. But here, the legal landscape is also on a bit of unsure footing. There is a case before the US Supreme Court, again, out of North Carolina, called Moore v. Harper, which presents the question as to whether state courts can even weigh in on the way that congressional maps were drawn. Though the other thing that happens in state courts, of course, is many times states elect justices, or the courts get politicized in other ways. And one of the things that happened in North Carolina is there were judicial elections. The court now looks very differently, and the court is revisiting its decision to strike down maps under its own state constitution. But as of right now, there were favorable partisan gerrymandering rulings in Alaska, in Maryland, in New York, in North Carolina, in Ohio, and in Utah. But with North Carolina revisiting, the Utah Supreme Court is taking up the case. The New Mexico Supreme Court is taking up a case. In Ohio, things are ongoing, and there too, the court is now looking different. And certain states where claims were unsuccessful, the amount of relief that's available from state courts is highly, highly variable and really based on the composition of each state court. So I'll leave it at that and pass things over to Kim, but of course, happy to answer questions and discuss further.
Thanks. Yeah, so North Carolina, always a hotbed of trouble, although I think like one of the more amusing things right now is because of these dastardly attempts to have our Supreme Court revisit a whole host of rulings that our previous court made a few months ago, means that the US Supreme Court is now saying, why are we even getting involved in this issue, which apparently is not a final decision out of North Carolina courts. So maybe they will have gotten in their own way in that particular situation. And the Moore v. Harper case may disappear and may not have the mass impact on the United States that people were worried about, and we'll just be stuck with our problems in North Carolina. But I'm going to take you back. There's so many different lawsuits you will hear coming out of North Carolina, both federal and state, and that partisan gerrymandering ruling last year was, pretty monumental under our state constitution. We were also responsible for the Rucho case, which prevented partisan gerrymandering from being considered at the federal level. So always lots of law coming out of our great and closely divided state. But I'm going to take you back all the way to 2017 to talk about a story that we got involved in. And I should start by just introducing myself. I'm Kim Meyer. I'm with the Southern Environmental Law Center in Chapel Hill. I am the litigation director, but when this started was just a senior attorney working on a variety of things, and never realized back when we took this case in 2018 that I would still be working on this case and the various pathways that it would take. But for those of you who are not familiar with SELC, we are a not-for-profit law firm similar to Earth Justice. We represent groups throughout the Southeast, 6 states in the Southeast, Virginia, North and South Carolina, Georgia, Alabama, and Tennessee, and work on a whole range of different environmental issues. But this was really the first time that we got involved in democracy work. So what I want to do today is talk a little bit about how that happened, what that looked like, and some of the lessons learned, both positive and negative, and to talk about, why is it important? I get the question probably at least once a week, why are you at the Southern Environmental Law Center involved in this case about voter ID and gerrymandering? And I think there are great answers to that, but I know it's not, naturally what a lot of our groups have done. So to set the stage a little, back in 2017, the United States Supreme Court finally affirmed in a case called Covington that the North Carolina legislature was the product of a widespread racial gerrymander. In fact, the lower court called it the largest gerrymander ever encountered by a federal court. 2/3 of all of North Carolina's legislative districts had to be redrawn. This was racial gerrymandering. This was not partisan gerrymandering. This was racial gerrymandering, and was just so extreme and blatant. What we found, however, is that there are lots of tricks that the legislature could use, that even though it had lost, the remedy of redrawing those districts ended up being delayed and delayed and delayed and delayed. So that you have legislators sitting in illegal districts. That you have people, particularly voters of color, whose voice is not being heard in the way that it legally should be. And yet this legislature is still in power, and, you know, filing motions for this and that, and delaying new elections. And in the environmental field, we're looking on while this legislature, which now, you know, has been fully called out on its racial gerrymandering, is continuing to enact law after law that really damages the environment and puts people's health and welfare at risk. I mean, I can't tell you the devastation that was done to North Carolina since this legislature took over in 2010, but every single environmental law that you can think of was decimated. We have a lot of issues with CAFOs in North Carolina and the eastern part of North Carolina that particularly impact Black and Brown communities and low-income communities, and a lot of those safeguards that were protecting those communities and their ability to sue to protect themselves. For example, we're just being slashed right and left. So we were seeing environmental harm and harm to communities throughout our state, and sitting there and feeling so frustrated and angry that this legislature had been declared a legal racial gerrymander, but was still in power. And so we started to think, well, what theories are there under our state constitution which might limit the power? We know that we can't just say that these legislators can't act at all, but surely there has to be a limitation to what you can do after you've been declared a racially gerrymandered legislature. And so after lots of thinking about this, a opportunity presented itself, which was that our legislature on its very last week in office decided to put 6 constitutional amendments on the North Carolina ballot. And the way that constitutional amendment works in North Carolina is that you first have to have a full 2/3 of the House and 2/3 of the Senate. And that's not 2/3 of members present, that is 3/5 of everybody. And then it goes for a vote of the people and a majority up or down vote. But that first step is crucial. It has been there throughout history. I know other states have just popular referenda. We do not. And so what we started to think about, surely the safeguards that are in there are to protect our democracy and the will of the people in amending their own constitution. And it can't be that a legislature that is only has that 3/5 majority because of illegal racial gerrymandering, they can't surely have the power to amend our constitution. In many ways, that seems just like so obvious and fundamental to democracy. Apologies for a little front here. But it was a really novel legal theory, and initially just like completely out of what anyone had previously thought about like what is the power of that racially gerrymandered legislature. And the constitutional amendments at issue, 2 of them in particular really concerned us at the Southern Environmental Law Center because they had to do with the way that our state would elect or would appoint judges during when a judge had retired, how they would be replaced, and how boards and commissions, over 350 boards and commissions in North Carolina, would be appointed. So those were things that were just like really central to what we did at SELC. But 2 other amendments were also important. One was to lower the income tax rate, to fix it at a super low rate, which was problematic for us because we're thinking, well, that's less tax revenue for all the things that we care about, and particularly with climate change coming and all of the disasters which might come, and of course is a really regressive form of taxation if you're taking that income tax off the table. And then the last one was voter ID, which we really cared about because, as we're talking about here, who gets to vote has an impact on our democracy and has an impact on environmental outcomes. So we talked about it. This was an extreme emergency situation where the legislature passed these amendments and they were going to be on the ballot in just a few weeks. And we made the call to represent both the NAACP and an environmental nonprofit called Clean Air Carolina, and to jump in and file a preliminary injunction and try and get these amendments to not be on the ballot based on this theory that a racially gerrymandered legislature did not have authority to put them on the ballot. Now, the rest of the story, I could tell you all over a drink sometime. It's a very long and windy and very probably the most stressful time of my life. I think we filed, 5 or 6 briefs in a matter of days. We were getting rulings at 5 p.m. and filing new briefs by 7 a.m. the next morning. And in that initial round of preliminary relief, no one was willing to take on this legal theory. We did end up getting a couple of the amendments rewritten under a different legal theory. And so 2 of the amendments, the ones about these boards and commissions and judges, had to be rewritten. They were put on the ballot in a much more understandable format and ultimately failed. But the other amendments were allowed to go ahead, voter ID and the income tax cap, and they passed. But our litigation was still going. While we hadn't gotten that preliminary injunctive relief, we had filed a motion for summary judgment, and we always kind of felt like this sort of novel legal theory was going to require some time. It wasn't something that anyone was going to jump in and adopt in an emergency relief type situation. So we persevered. The problem for me as an attorney at Southern Environmental Law Center at that juncture was, not only had we lost kind of the 2 amendments, which were maybe more squarely in the purview of what it is that we usually work on, our environmental client had also been found not to have standing along the way. Totally bogus ruling, but one that we just didn't have time to appeal given the way that the case was coming. So then we're in a situation where I am now the lead attorney for the NAACP in a case about voter ID, which just looked a little unusual, I guess, but kudos to SELC. We were fully behind it for all the reasons that I have mentioned. And of course, the income tax cap was still really important. And so we committed to carry on with this case. And that was the end of 2018 was when we filed our motion for summary judgment. I argued in Superior Court in January of 2019, and in February of 2019, Friday afternoon, I was actually presenting at a CLE. We got the order in from the trial court that we had won, and the whole of North Carolina went totally crazy, on the right, like this is an insane legal theory. And then on our side of things, people started to come around to like, oh, this actually makes sense. Why should a racially gerrymandered legislature be able to do all of this harm? So the case has proceeded since then, and on the way we have been able to pick up a lot of allies, such that we went into the North Carolina Supreme Court last year with the governor as an amicus, with the Legislative Black Caucus as amicus, the ACLU. We had partners from really all over the state, and the biggest lawyers in North Carolina writing all of those amicus briefs. So it was a great story of kind of sticking with this legal theory, being brave, and committing to it. And one reason I bring that up is, a lot of people would ask me, well, why is it y'all that are bringing this case? And the reason is no one else was willing to do so. We were the ones who had come up with the legal theory. And the NAACP, as they so often are, were really the only group who were willing to stand up and say, we know this is a little unusual, but this is about fundamental fairness and democracy, and we are going to stand up, and we are going, and even if we get laughed at the beginning for how kind of off the wall this theory is, we are willing to do that. This is part of our long struggle. And I felt really proud to be a part of that, but it was a good lesson to me of sometimes, you get in these situations because no one else either has the resources or the willingness to kind of go out on a limb. So I argued that case last Valentine's Day, and we, in the end of August of last year, we got a ruling from the Supreme Court, ruling in our favor, finding that there are limits. This is the first ruling ever in the United States to find that there are limits on what a racially gerrymandered legislature can do. It was a slightly mixed win, because what the court also said was, but you've now got to go down for fact finding to figure out whether those two amendments that you challenge fall in the categories of types of amendments that racially gerrymandered legislatures are allowed to pass. And the reasoning was sort of like, well, we can't prohibit this legislature from doing everything because you've got to continue to have a functioning democracy. So we're going to really focus on types of acts that would further disenfranchise the people who were left out of the process in the first place. And I think that's fine. But as Yuri mentioned, we're now in a situation where our court turned over in the last election, and the court has asked to rehear at least 3 now of the most important cases of the prior term. Our case is a little older, so I don't think they can use a regular rehearing procedure to revisit, but this new court has no concern about precedent and is just willing to come in and be like, nope, we're making the dissent the opinion now, which is, just very, very hard for those of us who have worked for so long on all of this and to put so much thought into legal reasoning and argument, and to think that there's just nothing matters anymore. So we are now, I guess, technically back in the trial court and not in any particular rush to do anything, but we are waiting to see sort of what happens next. But a few lessons I've learned along the way. First is that this type of work is a really long struggle. And I think there's a couple of things I mean by that. One thing that was really meaningful and important for me along the way in representing the NAACP was thinking about how this particular case fit in with, of course, a decades-long, centuries-long struggle from this community, and that the legal decisions I might usually make in a case might be at odds, or potentially could be at odds with a large narrative, or could rub up against just that bigger struggle is so much more important. And to be able to put that first and to sort of think about the client in that way was sometimes challenging and very different than the type of like shorter term environmental case that I might be used to working with. The other, in just terms of like my actual time, I don't think we ever thought when we entered into this case in 2018 that it would be 2023, and I would still imagine that we've probably got 2 or 3 years left to go. And the types of issues we got dragged into along the way. Part of this case ended up in us having to brief for the North Carolina Supreme Court how judicial recusal would be decided in North Carolina, because in North Carolina right now, one of our justices is actually the son of the head of the Senate, who was the named defendant in our case. So we ended up becoming the first case for that conflict to emerge in, and suddenly, spotlight on us at the Southern Environmental Law Center is suddenly at the center of briefing judicial recusal policy for the entire state of North Carolina. So, which is great and important, and it is so important for environmental groups to be at the front of everything about when you're thinking about fair democracy and fair courts. But it's not something I expected, and I don't think it's anything that my bosses at the time would have anticipated down the line. So I think the big lesson is, go into these big long-term struggles with your eyes wide open of what you are getting into, and you're going to have to fully commit to like what could come up along the way. On the positive side, not that that's not positive, but the benefit, I guess, is that it has allowed me to just create wonderful partners with folks doing this work in a larger context throughout North Carolina and ultimately across the United States in a way that I think is just really beneficial to our work, particularly as we move into a greater focus on environmental justice and justice. Having those partnerships and being able to have built up that trust and that willingness that we would stick in with this fight for so long, even though it's a little out of our norm, has, I think, allowed us to create a lot of really positive relationships and be able to show up for communities in a lot of ways that we just might not have been able to in the past. So I'm really appreciative of the journey that I've been on and that we will continue to be on. And I just think, as Yuri mentioned at the beginning, like, you can't look at any of this work in a vacuum. In North Carolina, we have so many hurricanes. I think about this a lot, that are, of course, being exacerbated by climate change. And then what happens when there's a hurricane? You have displaced people who don't have voter ID and can't get to their voting precinct, and all of that has been exacerbated by the fact that they're in these gerrymandered districts and haven't had the political power to advocate for better remediation of their homes and their roads. And so it's just so front and center to me how all of these issues interact, and doing this work has really allowed me to see that more. So I really was so thrilled to hear that this panel was happening, because I often feel a little alone in the environmental community and a little bit of a weirdo for doing this type of work. So I'm so grateful for the panel and the hosts who are putting this together, and I will pass it along.
You just missed it, Kim, but they gave you a very great round of applause for that. Yeah, thank you, Kim and Yuri, for those great portions of our presentation. I thought it was very important that we kind of started this conversation framing both from the national perspective as to what redistricting is, because I know not everyone actually fully understands what redistricting is, besides just like it happens. And then Kim's narrative with the Southern Environmental Law Center, I think, really is a really good illustration of like what these cases can look like, and also why an environmental organization should throw themselves fully into this work. Ultimately, the reason why I originally wanted to bring this panel together is mostly that, like Kim, I was thrown into democracy work as an environmental attorney about 4 or 5 years ago, 2018, 2019. I graduated from law school in 2017, wanting to be an environmental attorney. I still am that, but I did not expect in any way whatsoever that I would be working on democracy in the way that I have over the past 4 to 5 years. And ultimately, that's because the story of Ohio, which has been hinted at by Yuri, and it's a very similar story to North Carolina with some similarities. Ohio is an incredibly gerrymandered state. It has been gerrymandered for 13 years now, essentially. My first election was 2012, when I was able to first vote. I have not once ever voted in an election in Ohio that wasn't gerrymandered. So like, I've never been able to vote in a non-gerrymandered election. And Colleen, I believe that's the same for you as well. So like this is a very personal narrative when it comes to me and the communities that I live in Ohio. Like we people, you know, at the national level, people will talk about Ohio and the way that it's going in policy and stuff like that, and talk about it as like, oh, it's, it used to be like a quote unquote purple state or whatever, and now it's firmly red or whatever. And like the reality is it's a gerrymandered state. It's not a red state or a blue state or a purple state or whatever it is right now. That we don't know what Ohio is because it's gerrymandered. And gerrymandering has an incredible depressive effect on people's desire to even participate in the political process when they don't feel like their voice matters in any way whatsoever. So very happy that we're here today. Our presentation is going to be focusing a little bit on the gerrymandering fight in Ohio as it has played out over the past few years. But then specifically, we want to look really deep at the data to really illustrate how districts, as they are drawn, can end up really, really exacerbating environmental injustices in the way that communities get split apart based on the environmental harms that they're experiencing. So part of this discussion, and you've heard this a little bit from Yuri and Kim already, there will be discussion around like, Republican districts, Democrat districts, and, that's part of the way that gerrymandering plays out. When partisan gerrymandering is the issue, you have to talk in these partisan terms. But ultimately, as Yuri said at the beginning, good redistricting has nothing to do with the political parties at play. It's about creating geographic constituencies and population constituencies that have Yuri used the word glue. That is like there's connective tissue between the community as they get represented at different levels of government. And the work that Kalia and I did during redistricting advocacy in 2021 was fundamentally focused on trying to bring those environmental justice narratives into the conversation when our maps were being redrawn. So that's the framing. Just real quick before I forget, Kim mentioned that the North Carolina Supreme Court had a son of a lawmaker on their court, and it's just wild because Ohio has that exact same issue. We have a sitting justice who is the son of our governor, and he did not recuse himself during all of our litigation, except for the one time when the court briefly considered some briefing on holding the redistricting commission in contempt. He did briefly recuse himself for that, but otherwise ruled on everything. So with that, we'll get started. So at the Ohio Environmental Council, the saying that we have is that a healthy democracy, a healthy environment requires a healthy democracy. You cannot pursue and achieve a healthy environment if you have a non-functioning democracy. This may seem like a very obvious statement, but a lot of people don't really think about democracy in this way. When we're talking with environmental advocates across the state, there are still plenty of people who, like Kim, ask us, why are you doing democracy work? Like people don't always see the connection. Now, hopefully you all in this room are seeing the connection if you didn't already. But that's part of what we want to make sure is if you don't already think that democracy is something that you should be fighting for in your environmental advocacy, they need to be wedded together. And so because fighting for fair maps leans into values of good governance, justice and equity, a participatory democracy. When we're talking about environmental harms that are experienced by individual communities, if they don't have a pathway to advocate to fix that harm, it's going to make it a hell of a lot harder for them to really fight against that environmental injustice. So our roadmap for this, we have how did we get here? A recent history of redistricting in Ohio. I've kind of teased that up already. A brief bit on Ohio's constitution. We had two redistricting constitutional amendments in 2015 and 2018 that changed how our redistricting process occurred a decade ago to now. Spoiler, it didn't work totally. It did in some ways, but it also didn't in other ways. Then we'll dive into our approach to infusing environmental justice into redistricting and how we kind of use that as an advocacy tool during the redistricting process. And then ultimately what the result was here in Ohio. And then ultimately, I think when we get to the Q&A session, and I'm hoping we'll have a good 20 to 25 minutes for that, we can really dive into like the power dynamics at play that have resulted in where Ohio is now and how that impacts other states as well and the country as a whole. So in Ohio, environmental justice injustices look probably similar to some of the places you all are from, but also, every state has a little bit of a unique unique reality. So in Ohio, we have plenty of sacrifice zones, especially throughout Southeast Ohio. Southeast Ohio is a epicenter for oil and gas extraction. The Utica and Marcellus shale plays are throughout the region. And so a lot of the recent oil and gas development in this country over the past decade and a half has occurred in Southeast Ohio, West Virginia, and Pennsylvania. The region itself, Southeast Ohio, has seen a legacy of extractive industries from coal and timber as well. The forests in Southeast Ohio, most of them are only 50 to 100 years old because the entire forests were literally just destroyed in the 19th century. Air pollution in our cities, Ohio has 3 large cities, Cincinnati, Columbus, and Cleveland, all about 1 million people. And all 3 cities are relatively segregated when it comes to where their communities of color live compared to white communities, and all of the air pollution and environmental injustices that you would expect play out in our cities as well. There is a regulatory preference for fossil fuels. This past legislature, Ohio passed a bill called Senate Bill 52 that intentionally excludes renewable energy from being sited in counties. So counties can create exclusion zones that bar solar and wind from being constructed. They cannot exclude other forms of energy generation. So it's essentially designed to prop up the fossil fuel industry long term. We have regulatory capture of our agencies, especially the Public Utilities Commission. Has anyone heard of House Bill 6? One hand raised. Okay, great. So House Bill 6 was a bribery scheme where First Energy, one of our public utilities, bribed our Speaker of the House $61 million to pass a bill that was designed to bail out coal and nuclear plants. One of the coal plants wasn't even in Ohio, it was in Indiana. And so that trial is actually ending this past week. Fortunately, the FBI and the Department of Justice are attempting to convict him of said bribery. But that's a part of our state house dynamics. And then we also have things like one of the highest rates of lead service lines in the nation when it comes to people's drinking water. So fair
Can I
map.
just add to that really fast?
Yes, go for it.
Yeah, just as Kim, we'll be back and forth throughout this presentation.
Yeah.
You know, Kim touched on that, but I just want to take a second to ground us that when we're talking about environmental injustice in Ohio, it's specifically how these environmental issues impact communities that are already experiencing issues due to their, race, ethnicity, socioeconomic status, and immigration status. So, we think about how sacrifice zones relate to redlining in Ohio cities. When we're talking about renewable energy and utility bill reform, there needs to be this focus on the BIPOC communities who don't have AC in, heat wave Ohio summers, and their communities don't have urban tree cover. Ohio, our state might not have pristine public lands and a state house that prioritizes environmental policy, but I really like what Chris said yesterday about the fight is in Ohio. And the fight needs to center these BIPOC communities. So pass it back to you.
Thanks, Kalia. Yeah, and I'm glad you mentioned heat waves. That's a really good example of Ohio is relatively landlocked. We're not experiencing sea level rise the way that coastal states are when it comes to climate impacts. But we are seeing the increased temperatures, the high heat days, the high precipitation days. And last summer, we actually had a heat wave combined with a derecho. If you're not from the Midwest, you may have never heard of a derecho, but a derecho is essentially a windstorm and rainstorm that just sweeps across the Midwest. And so we had a storm come through and then 105-degree days, and about 300,000 people lost power for 3 to 4 days during the heat wave, combined with the storm. And so that's an example of the sort of climate impacts that we experience. And there's really good evidence to indicate that the utilities who haven't been modernizing our grid and have essentially captured our legislature, if they'd actually been doing the sort of grid modernization efforts that advocates have been calling for the past 10 to 15 years, the impact would have been significantly reduced. But ultimately, so healthy democracy means, that we can create a healthy environment. The fight for redistricting is part of the fight for the climate crisis, for safe drinking water, for accessible public lands, and many other issues too. In the end, it's a matter of ensuring we have a government that works for the people, not for politicians, not for corporations, not for wealth. It's ultimately about flipping that script. So Redistricting in 2011, Ohio, this is before we had a new redistricting system. In 2011, Ohio's legislature essentially made our maps in a back room of a hotel. This is not a joke. Like, literally, there was a place called the Bunker, which is a hotel room in a hotel downtown. They drew the maps really quickly, took them to the legislature, passed them really fast. And then the Ohio Supreme Court ultimately ruled them as constitutional because there was no language in the Ohio Constitution that they could be used to invalidate them. And so since 2011, we had state house maps that essentially enshrined a supermajority of Republicans in our Ohio legislature, which I don't know the exact data for North Carolina, but I would guess that it's a similar narrative, that that's exactly what happened, except that was a racial gerrymander. We had a partisan gerrymander. And so in this is what our maps look like for the last decade. So on the left, you have the Senate. On the right, you have our state house map. Left is our congressional map. Apologies. Left is our congressional map. Right is our state house map. I don't have the Senate map up here for Ohio, but essentially you'll see that a lot of our cities, they've done things to like tease out, like pull in like rural regions, dive into cities, and then dilute partisan votes. This is especially apparent in Cincinnati, which is down on the bottom left of the map. And then Cleveland, Akron, and Canton, which are up in this region up here in the Northeast. That tactic was used effectively as well. So in 2015 and 2018, we had constitutional amendments to amend how our redistricting process worked. These were a combination of citizen advocacy, where groups were gathering signatures to try and put a constitutional amendment on the ballot. We can do that in Ohio. The threshold is very high, but it is not impossible to gather the signatures and pass constitutional amendments. But ultimately, both of these constitutional amendments were actually submitted by the legislature to the voters. Essentially, when they were gathering enough signatures to potentially put these on the ballots, the legislators themselves called the advocates to the table to negotiate language. So then in an ideal world, that's actually not a bad thing, because then you can save a significant amount of money and not have to continue to pay signature gatherers, and you can put the constitutional amendment before the voters much more quickly. However, and we'll talk about this a little bit later, in retrospect, the legislators used that process to potentially undermine the policies themselves. And we'll talk about that a little bit later, how that played out. But ultimately, there is actually some really good language in these constitutional amendments. So for instance, we have no General Assembly district plan shall be drawn primarily to favor or disfavor a political party. That language is in the Ohio Constitution. We also have that there's supposed to be the statewide proportion of districts whose voters, based on statewide, state, and federal partisan general election results during the last 10 years. Sorry, I lost my train of thought. Yeah, so essentially, I'm not going to read that because the language is wonky. Essentially, however the votes turned out in the past 10 years for statewide elections, so like the governor, Senate races, Secretary of State, Attorney General, et cetera, whatever that proportion is of like Democrat voters and Republican voters, our map is supposed to roughly match that proportion. So over the past decade, Ohio had about 54% Republican votes in those races and 45% Democrat votes in those races. And so in theory, we're supposed to have a 54 Republican legislature, roughly speaking, and a 45 Democrat legislature. Spoiler, it did not turn out that way for our election this past year, and we'll get to that. And then the 2018, the congressional redistricting was also reformed and had similar language. General Assembly shall not pass a plan that unduly favors or disfavors a political party or its incumbents. So in Ohio, we have in theory language that is supposed to protect us from partisan gerrymandering. All right, so I'm going to be kicking it to Kalia here in a second, but that's kind of like the baseline for what redistricting looks like in Ohio. We had these two new processes that was supposed to play out in 2021. And then ultimately, that's where the work of Ohio Environmental Council and a bunch of our other partners came in, where we're like, okay, we have these new processes. We're supposed to have an Ohio Redistricting Commission made up of a bipartisan group of leaders Yuri mentioned that earlier, they were required in the language to hold hearings, and we're like, okay, what is this sort of public advocacy going to look like? How are we going to engage? And so we did two things: a lot of public education, and then we actually created something called the Ohio Citizens Redistricting Commission. And by we, I mean some other organizations. I didn't create it. I actually did sit on it though. And the Ohio Citizens Redistricting Commission was an external venue that was going to make its own maps. So with that, I will kick it to Kalia to keep the story.
Sure. Yeah, I'm just going to share how this Equal Districts Coalition engaged Ohioans in this process of redistricting. And here are just some of the many organizations that made up this coalition. And as you can see, they represent diverse issues. And that was the goal, to engage Ohioans based on the issues that mattered most to them, to get testimonies on why fair maps mattered to them. And as an environmental advocacy organization, the OEC was engaged in this redistricting fight, trying to highlight these intersections of democracy and environment. And through the community map making sessions that Chris and I led, and then later the maps that we made using EJ screen data, which we'll show later, we sought to illustrate how these district lines can impact the ability for Ohioans to speak out about the environmental injustices they're experiencing, and then how responsive their elected leaders will be. There we go. Just want to pull up this map making tool. So this allowed Ohioans from across the state to draw and submit narratives about what they viewed as their community. And over 2,000 community maps were analyzed by the Kirwan Institute for Study of Race and Ethnicity at Ohio State University and the MGGG Redistricting Lab at Tufts University to create these unity maps that were proposed to the Ohio Redistricting Commission as an example of what it looks like when you build maps that actually reflect the input of Ohioans. So for example, I'm going to zoom in here. This is the Mill Creek Corridor. It is an area of predominantly Black and Brown communities in Cincinnati who are impacted by environmental injustices from being in close proximity to these major interstates. And then there's also a lot of factories there. And what this tool allows you to do is to highlight, what are the bounds of your community, and then you can place points of interest, like where your church is, where where's the hospital, your grocery store, where do you access green spaces, or how far do you have to travel out of your community to access green spaces? So as we led these workshops, we asked participants to think about the environmental assets or the environmental issues in their community. And a lot of times that revealed the inequities of what communities had ample access to environmental assets and what communities had way more environmental issues. And I want to call to your attention this describe your community box that allowed participants to add written narrative. And this was important because it revealed truths about spatial relationships that you can't discern just from looking at a map. For example, in one of our workshops, we had a participant who lived in this Mill Creek corridor area and explained to us that there was a distinct separation between their community and the neighboring community. And from a map and from certain data, they may look very similar, both within close proximity to the interstate, both low income, but one community was predominantly Black, one community was predominantly white, that was historically a sundown community, and those dynamics between these communities still existed today. And it was important for this person to describe that when showing the bounds of their community. So that is the level of detail that these maps were trying to synthesize so districts could accurately reflect these community dynamics. Who's familiar with EJ Screen? Awesome, a lot of people. Yep, so this is a fantastic tool by the EPA, and it allows you to look at socioeconomic data and environmental hazardous exposure data But then the really cool thing is it allows you to overlay those things. So if we pull up, for example, air toxic cancer risks, we are looking at low-income communities of colors who have exposure to air toxic cancer risk compared to the state. So we took these tools. Let me just head back to the presentation.
Get back the slide. Oh, did you exit out of the slideshow mode?
Do you want to
Yeah.
get back? I think I just hit escape.
Yeah.
Okay, cool. Let me just go through this, pull up. There we go. So we took these tools and I imported the shape files of the proposed districts. And this became a very powerful illustration and visual of how gerrymandering splits these communities experiencing environmental injustices and dilutes their representation into districts where a majority of voters do not experience those environmental issues. And this disempowers the voices of people and perpetuates the harm being done. So this is the Cleveland metropolitan area in Cuyahoga County in Northeast Ohio. And this EPA data is highlighting low-income communities of color that have the highest percentile scores for lifetime cancer risk. And as you can see, districts 19, 21, 22, they're taking pieces of these communities and then, putting them into the rural communities out to the east. Similarly, this is the Dayton metropolitan area, Montgomery and Preble County of Southwest Ohio, and District 39 of the proposed Ohio map. It cracks the communities near Trotwood, Drexel, New Chicago, and forces them into a district that stretches out from Montgomery County all the way to the Indiana border. And these communities here in downtown Dayton face high environmental hazard exposure, respiratory hazards, lead paint, Superfund site proximity, and these are issues that are not experienced by the majority voters in this rural area. And this has been mentioned, but these issues stack when it comes and only worsen with climate change. So these are the very communities that were impacted the hardest when the May 2019 tornado came through Dayton. So loss of power, clean water, and damages to homes and their community institutions disproportionately impact these communities when they're already burdened by economic marginalization and an unresponsive legislature. And then perhaps District 1 was one of the most egregious proposed districts, because why should those in inner city Cincinnati be put into a district with the entirety of rural Warren County? Yeah.
The whole green area, that's a district?
Yeah, so this is a congressional district. The previous ones were state house districts.
Yeah.
This is a congressional district.
That's a beauty right there.
Yeah. During our hearings at the State House, people were coming up with like creative names, like, you've heard like the duck district. There's a district that looks like a duck. I started calling this the deadly dumbbell because just like, why is it shaped like that? But yeah, so for these maps, we use these to illustrate that across the state, the cracking apart of communities and this haphazard connection of communities with wildly different experiences, this diminishes the ability for Ohioans to advocate for their needs. And they enable the recurring election of legislators who are unresponsive to these harms. So I'll pass it on to Chris now, and he'll share a little bit more about the process and how these maps made it into the lawsuit. All of that.
Yeah, going back. So yeah, we may have messed up the order of our
That's all right. We're flexible.
our slides a little bit. But thanks for bearing with us. So here's just a real quick example of a community map as like what a final look could look like. So this is actually one that I made for the community that I live in Columbus. And so you can see you can put locations on it. And then on the right here, we have the fact that it's actually divided by 3 districts. So the Ohio Citizens Redistricting Commission that I mentioned, that commission ended up making 3 maps: State House for the Senate and our House, and then a congressional map that took in all of these community map making data and attempted to draw maps and create maps that actually fit the constitutional requirements, specifically that partisan divide of 54 Republicans and 45 Democrats. And so you'll notice here we actually were able to do 44 Democrats, 55 Republican seats, 15 Democratic seats, 18 Republican seats. And then there were also minority opportunity districts for both the House and the Senate as well under these maps. So this is what the OCRC created. And then we had the redistricting process itself in 2021, where here's both Kalia and myself testifying at different hearings before the legislature.
Frustrated.
So the State House redistricting hearings were, they essentially waited as long as possible to start the process first. So even though they had requirements, they did everything they could to stay as like within that bounds as possible, not creating a more expansive participatory process. They did hold hearings throughout the state, which was a nice thing. They didn't hold them just all in Columbus. They hopped around. There was near unanimous opposition to gerrymandered maps. And then they also didn't allow any virtual testimony. But so Kalia and I and some other environmental advocates at these hearings were testifying, talking about these narratives before they proposed maps. And then after they proposed maps, we were actually able to overlay the data and show what the maps they were proposing and how it was dividing up these environmental justice communities. The congressional redistricting process, they delayed as long as possible as well. They held no hearings in September or October, and they actually just kept it out of the Ohio Redistricting Commission entirely and just had the legislature do it. Our system is weird. It's month by month where it starts in one venue and then goes to another venue if you can't make a decision, and then if the decision's not made, it goes to another venue. We don't need to go into the details of that, but we created a strange process in Ohio. There's good pros and cons to it, but so the first maps were horrible. We had Ohio House, 64 leaning Republican districts, 35 leaning Democratic districts. The Senate was about 23 to 24 Republican districts, 9 to 10 Democratic districts. And then the congressional map was 12 Republican districts and 3 Democrat districts, which was somehow worse than the congressional map we had for the past decade, which was 12 Republicans and 4 Democrats. Yeah. So what that means is that we filed a lawsuit. And Yuri Radinski, who is one of our co-panelists, actually with the Brennan Center, was representing us, and we had other law firms engaged as well. But it was the Ohio Environmental Council, the Ohio Organizing Collaborative, which is a voting rights democracy organization in Ohio, the Council on American Islamic Relations of Ohio. So we were the 3 organizational plaintiffs, and then we had 6 individual plaintiffs who joined the lawsuit as well. And we filed using those new constitutional amendments for the redistricting process as the framework, but then ultimately our violations were, we're like, look, they intended to draw districts to favor Republican voters over Democratic voters. So that was our legal argument. But from the Ohio Environmental Council's perspective, the reality is that partisan favor, their intention to draw the maps with that partisan favor has the potentially intentional, but at the very least, unintentional side effect of breaking up these environmental justice communities. And I want to make sure we have a lot of time for Q&A, so I'm going to probably move us a little bit more quickly. But ultimately, we did win our lawsuits. And Yuri can talk a little bit more about what the state of the lawsuits right now, if someone has a question about that. But the gist of it is that we won a combined 7 times before the Ohio Supreme Court in 2021, in 2022. The suit was originally filed in 21, and then all the decisions were in 22. But what happened is every single time the Ohio Supreme Court said this map is unconstitutional, it went back to either the Ohio Redistricting Commission or the legislature. Legislature was in charge of the Congressional Redistricting Commission for the state house maps. The Redistricting Commission would change a few districts, change some lines, and I'm simplifying here, but that's essentially what they would do. Send the map back, and then the Ohio Supreme Court would say again, it's unconstitutional for slightly different reasons as they changed it, but then it just played ping pong with the court. And ultimately, it got to a point where we had to have elections, and we ended up having elections in 2022 under maps that were ruled unconstitutional by the Ohio Supreme Court because the legislature and the legislative branch and the members of the Ohio Redistricting Commission, which includes statewide elected officials like our governor, and as I said earlier, the governor's son is on Ohio Supreme Court. They just ignored all the rulings of our Ohio Supreme Court. And the reason why they were able to do this is because they relied upon a provision that was in the constitutional amendments that said that the court cannot draw a map. And so remember when I said earlier that the legislature ultimately was the body that referred this constitutional amendment to the people because there was that compromise process. That was a piece of language that they slipped in, that the Supreme Court could not draw a map. And so this is, be very clear, I don't know this for sure, purely conjecture. I think it's very likely that in 2018, when they were in 2015 and 2018, when they were finalizing the language, they planned on this as being the way the process would play out, that they would just stall it out and allow the maps to be no matter what the court said. And importantly, in 2022, our Chief Justice of the Ohio Supreme Court, her name's Maureen O'Connor, she was a Republican. She was siding with the 3 Democratic justices on our court. So we actually had a bipartisan majority of our Supreme Court finding these maps unconstitutional. She was termed out this year. And this past 2022 election was the first election where we had partisan identifiers next to our Supreme Court justices. They had added that in the past few years. And so now, so we now have 4 Republicans again on our Supreme Court, 3 Democrats. One of the sitting Democrats had been running for Chief Justice, and then there were 2 other open seats. All the Democrats lost. So we have 4 Republicans, 3 Democrats, and it's fully expected that they will be reconsidering these cases in some form.
I have 15 minutes. Do you want to
Yeah, so yeah, I want to make sure we have time for questions. So I think we're going to skip through these. Here's Ohio. These are our final gerrymandered maps. So just quickly, I want to compare. So this is what we ended up with. You'll notice District 1 ended up with a slightly different shape than that barbell that Kalia was describing. And I had a comparison somewhere around here of what the Ohio Citizens Redistricting Commission's District 1 looked like. It was fully contained within Hamilton County, which has Cincinnati, to give you an idea of like, they could have done that. And they intentionally drew Warren County into it. And so then we see the environmental justice data. So something that, just real quick to wrap up, as the cases played out, we as Ohio Environmental Council, we were a party to the State House map lawsuit. We were not a party in the congressional lawsuit, but we did file amicus briefs. And what we did throughout these amicus briefs was literally, I put these maps into these briefs and told this narrative of like, look, this is what is happening when this partisan gerrymandering occurs. You have these communities, both racial demographics and these environmental justice demographics being divided in half. So some more maps. This is Columbus. And then more examples. So yeah, I think, yeah, we'll shift into questions now. This took a little longer than we expected, so thanks for bearing with us. But you know, just a reminder, Ohio's maps were found unconstitutional 7 times. Our elections were all run under unconstitutional maps. There's going to be a redraw this year because those maps were unconstitutional. It remains to be seen what that redraw process is going to look like for us. But ultimately, redistricting reform is part of this democracy puzzle. Ohio's story is not done. We're still fighting. We're still figuring out what the solution is. I just know that from the past few years of doing this work, embedding environmental justice as the core of why we're doing this work has been essential, and data helps. So yeah, Kalia, do you have any final parting thoughts before we go to Q&A?
Honestly, I think let's just go ahead and float over to our audience. We want to pull back up the Zoom room.
Yes, and Kim and Yuri, I will, if someone, they'll ask the questions to me, I'll repeat them, and then give you all the opportunity to answer. Yes.
When you're testifying at these redistricting hearings, what's the primary opposition argument that you're getting for these super wacky districts?
Yeah, so the question was when testifying at these redistricting hearings, what's the primary argument we get for the wacky looking maps? And Kim and Yuri, you may have thoughts on this too. But essentially, they will often try and rely on the specific rules that are in the constitutional provisions about how the maps have to be drawn. They'll say, oh, there's only so many ways that the maps can be drawn, or we have to make it look this way because we can't divide jurisdictional boundaries a certain number of times. And oftentimes that is a little bit of a ruse, because you'll have in the lawsuits themselves, experts will be brought on who will have run simulations to generate maps following the rules that are in the Constitution. And they'll generate thousands of different variations. And the maps that were proposed at the state level in Ohio were always like the most unfair from a partisan perspective, even though they were possible. And then the deviations would usually be more in that more like the 45 to 55 range of Republican and Democratic districts. Kim or Yuri, do you have anything else to add there?
The only thing I would add is I do think it's important to not, we always say don't focus on the shape. There are crazy shapes. Sometimes there's really good reasons for crazy shape maps, and sometimes that's actually what we're advocating for. So while it can be kind of a good talking point, generally I think it's better to really think about, the actual issues, which is connecting their community and making sure that it's accurately reflected in the legislature.
The only thing I'll say is that the reality is, in most places, the gerrymandering is very brazen, and to the extent that there's even any sort of justification that's being given, it's rooted in things like incumbency protection, et cetera. And there are instances where you want to be mindful of things that are called, double bunking or triple bunking, where a district is drawn where incumbents would face off against each other. Though, of course, those are political concerns, not concerns about the relevant communities and how they're organized. But of course, when a map that is already an egregious gerrymander is taken, and the underlying goal is to protect incumbents and to be mindful of where incumbents reside and not double bunking them, that's just another way of perpetuating the abuses of the past and bringing them forward into the following decade.
Over here.
So I just have a question about determination of populations. So when you're doing determination, is it of voting adults in a district? Is it total population? And does it consider those who choose not to vote within that population, which could be large in certain areas, or those who are ineligible to vote because of criminal convictions, et cetera? So I'm just trying to get an idea of where they're pulling the population base from.
I can't speak for every single state.
Yeah.
At the federal level, I believe it's just straight population. So it's total number of people when you're drawing your congressional districts. And in Ohio, it's total number of people for our state legislative districts as well. There's a few important factors there. So at the federal level, districts can vary in population by roughly like, what's the number, Yuri? It's like, what, like 0.5% essentially.
There's no bright line rule, but it's the districts have to strive to achieve as close to equal population from district to district as possible.
And at the Ohio State House level, they can vary about 5% in size.
This includes children, every
Yes,
person.
and importantly, something that's relevant here is that different states will handle prisons differently, and often prisons are in rural areas, and some states will include prisons and the population in the prison as at that location versus where they may actually be from. So that's a relevant factor also plays into population distribution. Yuri or Kim, do you have anything else to add on that question?
Yeah, I mean, this is a really important question. Traditionally, well, since the 1960s, population across the country at all levels, outside of just a few outlier examples, has been divvied up on a total population basis. The eligible to vote population, though, is relevant when you're assessing a Voting Rights Act claim. And so there's a difference between representational equality, which is what the one person, one vote principle tries to achieve. And that requires considering all constituents, because the reality is There are people who aren't eligible to vote, but they still matter. They still need constituent services. The policy decisions that are made still impact their lives. And of course, if you excluded children and non-citizens from redistricting, you would pull representation out of cities, out of suburban areas that tend to be younger. They tend to have higher non-citizen populations, and representation would move out into rural communities. There has been a right-wing attack on this equal population principle and equal representation. I'm sure folks remember the Trump administration's plan to add a citizenship question to the census. One of the main reasons why the administration was looking to do that was to give states the data they needed to exclude kids and non-citizens from being counted when districts are drawn. This would be extremely discriminatory. I actually authored a study of this and looking at a number of different states where policymakers had floated the idea of adopting something other than total population-based districts. And the thing that you would see as a practical impact is a reduction of representation for Black communities, Latino communities, and for cities.
More questions? Yes.
I gotta say, I mean, in addition to that clapping earlier, the work you're doing, everybody, all the panelists are doing is amazing. Very much see democracy and environmental protection connected. I happen to be from California, and even though it does have the independent commission, some of the Central Valley districts, when I see what you've done or what they did in Ohio with the kind of reaching into urban areas from the rural areas, that's very much like Fresno County or some of the Central Valley communities. My question is there any essentially hope or possibility at the federal level of say legislation that will put some mandates on the states, and what can you sort of look to federally?
Yuri, I'll let you take that one.
Well, the Freedom to Vote Act, the John Lewis Freedom to Vote Act, got very, very close to passing. Of course, there were a couple of Democratic senators in the last Congress who were unwilling to change rules around the filibuster in order to give that really monumental and landmark piece of legislation a pathway through the Senate. There weren't Republican votes sufficient to overcome a filibuster, but that was really a remarkable point. Just the fact of the expansive nature of that legislation, the fact that the entire Democratic caucus in the House and in the Senate supported that bill is really remarkable, and it's really the most sweeping reform since probably the passage of the 1965 Federal Voting Rights Act. And so the challenge now, of course, government is split. There is absolutely no intention on the part of Republican House members to bring this policy to the fore, to hold votes or to get it through. But we at the Brennan Center remain hopeful that just given a broad public recognition for the need for significant reform and the kind of momentum that's already been built up, that passage is really a matter of when and not if. I think this is the sort of issue which, much to my surprise, I mean, when I started working on democracy issues, it was really not as broadly discussed and broadly understood as it is now. So for me, the silver lining is that the public cares and it matters to the public in ways that it really, I can't think of a time that it has. And we see it playing out in elections with you know, secretaries of states that candidates that were supporting election subversion and supporting Stop the Steal lost, and so the challenges are many. The abuses are severe, but I think there's been a really significant awakening, and so that really gives me hope.
So Kim and Yuri, we do have to end the Zoom in like 60 seconds. So I think it'll just close the Zoom. So first off, just thank you so much for joining us. Hopefully people can just give a quick round of applause. But real quick, before we lose them, does anyone have any final questions for Kim and Yuri? Holly and I can stay in the room, obviously, for a few more minutes. Take that as a no. Thank you both for joining us. Kim, it was really great hearing the full story of the North Carolina narrative. And thank you again both for joining.
Thank you so much.
Yeah, thanks all.
Bye.
All right.